Any mention?
Yes.
Item number 13. The learned legal aid counsel, she is unwell, so she cannot appear, Your Lordship. Dr. P. Agarwal.
It will go after vacation.
Yeah, after vacation, isn't it?
Yes. Mr.
No, BJ Das.
Lanesh Council appearing on behalf of Dr. P. Agarwal, Lani Council for the appellant. Praise for the matter. Learned AG appearing with the state has no objection. Prayer allowed. List after vacation. Yes.
Much obliged, Your Lordship.
Yes.
My lord, I beg to mention, my lord, item 12.
Yes.
I have some personal difficulty today, my lord.
Who is the other side?
Is there?
Sure, Friday. I've already advanced my arguments also.
Is it?
So it's for the state only.
What is this matter about?
Lordships for discharge. It's a 302 matter.
You could refresh the code. This code doesn't remember anything now.
Refresh. Lordship, not there.
We'll go after vacation. Then we know time to pass.
My lord.
Yes, as requested by Mr. Guru Lanik Ji, appearing for the state respondents. This is matter of vacation. Yes.
My lord, similar prayer for item number 5, my lord. I'm
Who is there
waiting.
on the other side, item 5?
I'll inform, my lord. Mr. Paul is there.
Yes.
Lordships, no objections, Lordship. They were supposed to.
Same order after vacation.
Deeply over.
Yes.
May it please Your Lordship, I beg to make a mention of item number 3. Lordship, my senior counsel is out of town. My senior counsel is out of town. You may. Lordship may have it next week.
Yes.
Lordship, normally we don't object, but on the last week, Lordship will recollect, private respondent was not present. Mr. Thapa was here and he was willing to start and saying that he will rely on the judgment. I don't know which way the case is going.
We should not allow the adjournment, but the only thing is that if it is not taken up today, the problem is Mr. Khan. There will be hardly any time for passing judgment. That is one thing, is passing writing an order.
Lordship can, even if the matter is heard and kept for reserved for judgment, Lordship can pass it. But the only limited issue is they don't have an enforceable right. Only that
Memory is not very good, not very lasting memory, forgets things very fast. So that is what the problem is. What is the difficulty? You have so many counsels.
More than 4 months. On the last date, Mr. Thapa appeared. Lordship will recollect.
Yes, where is Mr. Thapa?
He's having some personal difficulties, Lordship.
He is having personal. Mr. Paul is out of station. And then what else? There are as many 10 or 12 lawyers are there. Mr. Panthi is there. Where is Mr. Panthi?
And they've all argued in serially. Serially, everybody's argued.
Lordship may fix a short date, Lordship.
Short date is a problem. Now there is no time for short date.
Lordship, I have got on document certain records, which is of since Assam period.
Yes, this court remembers.
Lordship remembers.
You see, you say that this allotment was never accepted by them. So once it is not accepted, no right will accrue.
Yes.
That is the case, isn't it?
Exactly, Lordship. There's no enforceable right. Had they accepted, then things would have.
Is there any interim protection given here? No.
There was only for returnable date, and that expired long time back.
So then what is the problem?
Nothing. And there the third party right has been created, and the only problem is this: they don't want to take chances.
Why?
For the simple reason they invest money and start building up, and if there's an adverse finding, so probably that is working in the minds. And Lordship will kindly see the interim protection was given at the time of motion, and they chose not to.
2015. 2015.
Lordship, they chose not to even. And they choose not even
The
not to
problem is
extend.
that Mr. Khan, one thing is that you see, like if the councils are not there, then again that is
Lordship, I agree with it, and we don't want ex parte also. Lordship also doesn't encourage ex parte because then they come for review, they come for this. But the Lordship kindly appreciate at least more than 5 months they've been asking time only on this particular issue.
They chose not to reply.
And they chose not to reply.
Brought on record, Your Lordship.
The private respondent Lordship has brought that affidavit on record way back in 2020, 22 July, 22 July Lordship. And more than 2.5 years they chose not to reply, and then an oral argument was forwarded, and we got stopped in a particular issue.
day after tomorrow, Wednesday,
Obliged.
Obliged.
executed by the Lana Council of the petitioner. This is matter on business. Or tomorrow, whatever is convenient.
Day after, Lordship.
Day after.
Nice, Lordship.
Yes.
Your Lordship, I would like to mention item number 11. Your Lordship, kindly fix the matter after vacation.
Who is the other side? Item
No
11.
objection, Your Lordship. We've already filed our objection also, Your Lordship, in this matter.
Objection 2. What is the prayer here?
482, Your Lordship. Quashing.
Seeking quashing of.
Quashing of the order, Your Lordship. 144 was imposed, Your Lordship, where they had assembled, Your Lordship, more than 25 boys had assembled.
There is a prohibitory orders.
Yes, Your Lordship.
One and under 144.
Yes, Your Lordship.
And they violated the prohibitory
Yes, Your
order.
Lordship.
And the proceeding was done under 188.
Yes, Your Lordship.
They are seeking quashing of that.
Quashing, yes, Your Lordship.
How many petitioners are there? Only one.
Yes, Your Lordship.
If there is violation of 144, how come there is only one
No,
petition?
Your Lordship. There are other accused also, but only this petitioner
Has chosen to file
Yes,
this.
Your Lordship.
Yes. What is your prayer? Tomorrow.
After vacation, Your Lordship.
No objection, Your Lordship.
As requested by the Lana Council for the petitioner. This is matter after revision.
Highly obliged, Your Lordship.
Highly obliged, Lordship.
Your Lordship, I beg to mention item number 6. Kindly let this matter come after the vacation.
Who is it? Yes.
No objection, Your Lordship.
Yes. Straightforward by the Lana Council for the petitioner. Not objected to by the Lana Council appearing for the respondents. This is matter after vacation.
Obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 10. It is a joint request, my lord. And a similar matter is still pending before the division bench.
Your Lordship, the conducting counsel, Ms. N.G. Shalla, also is not available today, Your Lordship. That will come after vacation, Your Lordship.
The issue is pending before division bench.
Division bench, my lord.
Yes, Your Lordship, she's handling the matter.
Okay. As requested by the Lana Council for the parties. This is matter after revision. Yes.
Obliged, Lordship.
Your Lordship, I beg to mention item number 4. I'm appearing on behalf of the conducting counsel, Mr. VGK Kinta, as he is still under recovery, Your Lordship. Let the matter come up after vacation.
No objection, Your Lordship.
This also the request made on behalf of Mr. BG Kinta, Learned Senior Counsel appearing with the student. This is matter after. No, who is reported to be not well. Just before say, request has been made on VG Kinta, Learned Counsel respondent, who is reported to be not well, to adjourn the matter. The prayer has not been opposed by the Lana Council of the petitioner. Prayer is allowed. List after vacation. Yes.
For 7-8, Your Lordship, in this matter. For respondent 7-8.
You are appearing for 7 and 8. Just 6. Just record it.
Obliged.
Your Lordship, I beg to make a mention of item number 7. Your Lordship, due to personal difficulties, my senior is unable to take up the hearing today. Your Lordship, may the matter come up after the vacation.
This was expressed for the learned counsel. Just prayed on behalf of. You are praying on. You are there. You are advocates on record. You are an advocate on record here. No.
No, Your Lordship.
You are making a prayer on behalf of.
Of A Khan.
Yes, this is requested by so and so on behalf of so and so. Just write it. List of application. Yes. Yes, ma'am.
May it please your Lordship. Lordship, I beg to make a mention of item 8 on behalf of Mr. Thapa. He's appearing in this case on behalf of respondent number 2, Lordship.
Yes.
Lordship, I pray if this matter may be listed next week.
Next week is not possible. To ask for adjournment.
Lordship.
Go afterwards. Let's press for by. Yes, you have any.
Respondent number 1, your Lordship.
Let's press for by. So and so, learned counsel, let me give a respondent number so and so. This matter. Yes.
Grateful, Lordship.
The list item number 1.
Yes, Mr. Suna, what is this? This is anticipatory bail.
Anticipatory bail.
Is it released by the other bench?
Yes.
Lordship will just recollect it was released by the other bench. Then the complainant had filed
Application for intervention.
and Lordship had rejected it.
Has rejected that application on the last occasion.
What is this?
Lordship, this is the status report after the grant of interim bail. The earlier bench had granted interim bail.
The order is continuing.
That order is
Do
continuing.
you really need custody? Their custody.
Lordship will kindly see the report. He has not cooperated. Even after grant of anticipatory bail, he has never been present in the IO. So, Lordship will just come to the next page.
That's why you are not cooperating.
7, 8, 9, Your Lordship clause.
Such a big report. Why? What? This.
Especially if you come to page 3. Page 3, Your Lordship. 13, 14, 15, 16, 17. So I don't know whether they are really interested to get an anticipatory bail or 13, 14, 15, 16, 17.
Who is Gopal?
He is one of the
Gopal is the one of the
accused.
No, in this petition, who is the petitioner? In this
in item number 1,
yes.
Rahul Sharma is the
we are with item number 1 right now.
Yes.
He is Rahul.
Rahul Sharma.
Where is the case diary? You have a call for the case diary. You are having the case diary?
Yes.
You have the case diary with you?
We have the case diary. But the status was basically to apprise the important.
But then we have called for the case diary.
Lordship, case diary is there.
Just pass it from us.
My Lord, may I pray at this time? My Lord, in reply to what my learned senior has stated, that they are not cooperating in my humble and respectful submission. In this case, Your Honor, there are, my Lord, there are a number of multiple FIR against the petitioners. There is a case in Tura where the petitioner has already secured a bail, and there is also a case pending in the Bagmara. So because of this reason, it's not that the petitioners are absconding, but they are afraid because the complainant are laying trap everywhere to trap them.
No, but then this are all offence are punishable with imprisonment below 7 years.
Below 7.
So, was there any issue of notice under 41?
Yes.
And this is not complied with?
No, not complied.
Why you are not complied with 41?
And even
This is the reason, my Lord. There are multiple FIR against them because of that.
That is all right. You could have intimated. It is not that you have to appear on the same day, one day only.
On the last occasion, they have made an attempt to appear, but having learned that the police personnel from Bagmora, they are camping there in the Kanapara PS, so the petitioners have to run away. So, at this juncture, if I may pray, my Lord, give the petitioner last opportunity, my Lord. let them appear within a week. Then by next week, my lord will take call on this issue and then decide it.
Should have appeared by now, and then thereafter they could have examined you. Then maybe if they get the cooperation from you, they may not seek your arrest. We'll have it in these things. Let us see next week.
Next
Let
week.
the matter.
Last
But
opportunity.
then the problem
One
is
last
that if you,
opportunity
can
may
you
be
retain the CD? No, you cannot retain the CD for such a long time.
We'll transfer it also.
Then again, if it is needed on the next day,
We'll get back.
we'll have it next week. We'll just see.
He's made a fair submission, Your Lordship. I think.
That is exactly that is what.
He's made a very fair submission. Let him make an attempt.
See, now you are under protection. There is interim order.
My
You
lord.
should have appeared. You should have given your statement or whatever the.
That's what I have submitted, my lord. The only thing, the difficulty on the part of petitioner, because the complainant on the other side, she is laying trap everywhere and there. Once.
We will not say anything. Meanwhile, you will
My
go
lord.
and appear
My
because
lord.
this may create
Yes.
a problem. We'll just say we'll just adjourn it at your request, and then we may need it on the next day.
Lordship,
Return it for the time.
Okay. Please, Lordship.
Let's wait for Mr. Assumption. Learned counsel for the petitioner. This is matter after a week. We'll pass this.
Lordship, we'll try to get a fresh status report also.
That is better. And
but,
once he appears, once he records his
once he
statement,
appears, and situation is totally
you
different.
will still know more things. Just return it to him.
My lord, I have slight some small difficulty. Let it be before 13.
Huh?
Let it be before 13th.
Before 13th. What date is today?
Today is 3rd.
3rd, my lord. Otherwise, on 13, I have some difficulty. I cannot.
So today is 3rd. It is coming. It will come up. 1 week means 10th.
My lord. That,
isn't it?
my lord.
You list this matter before 10th or 11th.
13 you've got difficulties.
I have difficulty.
Let it be
On 13, I have got some difficulty, personal difficulty.
11th?
It will come up before that.
11th? No, 10, 11, 12, 18.
Just list after this on the aspect list this matter on 10th. Make it 10th. 10 also.
Deeply obliged.
All right.
Hearing item number 9.
Both the matters. Same.
Lordship, same matter.
Yes.
Please, Your Lordship, my lord.
Yes. What is the matter about?
This is a 482 application, my lord, seeking for a return of FIR. My lord, although this matter was heard at length, and I will again repeat it again, my lord, long time ago.
Long time ago.
At least 3 months ago, if I am not wrong.
On the last occasion, there was no appearance on behalf of the.
Well, that was we couldn't reach on time, my lord. If I may start, my lord. My lord, Your Lordship may come straight away to the FIR, my lord, page 23. And 24 it starts. Is Your Lordship got it? Page 24 it starts.
Just a minute. Page
24, my lord, to the FIR.
Yes.
I mean, page 24, my lord.
Yes.
Coming back to subject matter.
Go ahead.
This is a subject matter. Complaint against a contractor, engineer, supervisor, concerned manager of Food Corporation of India, Dura, implementing agency, any other person found to be involved in such criminal act. The present complaint pertains to a large-scale construction work at the rear portion of the FCI godown, which had involved massive mud filling to a tune of above 9 meters along with inferior construction of RCC retaining boundary wall carried out by the contractor, engineer, supervisor, and a concerned manager or FCI under the protection of implementing agency just above our lands without any water outlet, ensuing direct flow of rainwater along with mud, sludge, and silt being collected in the FCI godown into our compounds, thereby causing huge loss to our property, including damage to the fixtures and fitting. That is the main context of the IOL. The newly constructed warehouse on the loose soil has developed cracks, and the soil on which it has been built is eroding, whereas the RCC retaining boundary wall has developed bridges and is now tilting towards our property, and the retaining wall has collapsed into our property day before yesterday, that is 19 July 2020. This has resulted into shifting land destruction of our house and property there, and if no action is taken, it would result in a big catastrophe, including loss of human lives and washing away of our house structure. Further, it would be significant to mention that on 20th March 2015 and July 2019, similar complaints was filed at your police station pertaining to the mode and manner in which the said construction was carried out. The Darden Deputy Commissioner C. So-and-so took cognizance of the said complaint, who by said letter dated so had directed immediate stoppage of the construction work and directed the contractors and the FCI authorities to take necessary measures so that the rights of the citizens are not affected. The said order was issued by the Deputy Commissioner, was not adhered to, nor any steps were taken by them to stop such unlawful and menacing construction, which has now turned into a hazardous situation imminent to collapse on our property and likely to cause loss of human lives and damage to properties. Copies of the said complaint letter dated so-and-so addressed to a police station issued by the Deputy Commissioner enclosure 1. Then again, on 12 July 2019, an urgent meeting regarding the collapse of FCA boundary wall affecting our property and endangering human lives was called by the Deputy Commissioner Sri So-and-so, where after the contractors, engineer, supervisor, concerned manager, etc. had visited the site, they assured promised us to make good all damages and losses caused to us due to their fault, as well as to remove loose oil and demolish the illegal and unlawful construction at the FCA Godown. However, all in vain, as they neither made good the losses, damages, nor did they remove the loose soil and demolish the structure, which has now resulted in collapsing of the retaining wall into a compound on 19 July 2020, and further shifting of earth resulting to tittling of trees and damage to our properties. Copies of the letter were issued to the enclosure 2. The Deputy Commissioner on 19 July has taken cognizance of the matter in regard to recourse of the landslide below FCI Godown at Nazim Bazar and has instructed to take necessary action and put permanent solution immediately. Copy of the letter dated so-and-so has been enclosures 3. In view of the aforesaid, it is humbly requested to take strict action as well as register an FIR on the relevant provision of Indian Polling Code against the erring contractors, engineers, supervisors, concerned managers of FCI, implementing agency, and any other persons found to be involved in the said act. Here, I am not a named person in the FIR. What happened, here the work has been floated by the CPWD, which your lordship will find
What
it.
is the status of work now?
I have completed the work. I've done my part. And what will apart the logic?
When did you complete the work?
By 2022, my lord.
So you after this FIR also you were
After
allowed?
this FIR, also, I have been allowed to carry out the work under the supervisory of the CPWD. That is response number 1, 2. It is not that I've been working on my own.
You have been, you are an agent of this thing.
Yes, my lord.
You were a appointed contractor, isn't it?
Yes, appointed contractor, my lord, and the reason for such erosion was also been taken care of, where expert committee was constituted regarding the issue why it was happening, and the technical committee has also submitted a report to the CPWD, at which your lordship will find it page 47.
What is the date of this FIR?
This FIR, my lord,
21/7/2020. Where is the technical committee?
That's page 47, my lord. From the professor of IIT and all. Page 47, my lord.
Yes.
Here, my lord, the second paragraph, my lord.
Yes.
The settlement and the sliding of earth masses occurred during the rainy season in July 2019. The region is prone to heavy rainfall, resulting in natural calamity as substantiated by the records of India Meteorological Department with a rainfall of so and so. This is the reason they have stated, my lord. It's not because of that I have supplied inferior material or there was some negligence on my part.
No, if you supply inferior material,
I would have been
that will be
blacklisted,
for the
my lord.
department to like account.
Yes, I would have been blacklisted, my lord. And
Now,
here,
this is what? This is a report of the technical committee.
technical committee. This is the reason, my lord, in the page 48, my lord.
Yes.
There are several 48, my lord.
This is page 47.
48, my lord.
48.
It starts from page 47. When the report starts from 44, my lord, the relevant portion. At page 48, the site condition, my lord.
Now, when this report was prepared, what is the date of this report?
It was forwarded on 20 April 2020, my lord, to the executive engineer.
Where is the date?
It has not been mentioned here, but
How do you know this report is before the FIR or after the FIR?
this is if your lordship may come to page 42.
Yes.
Date has not been here. Report on site inspection in another project storage empty capacity.
If you see the date of this, then it is before the report. Before the
yes, because this was happening before.
So see, this report is not going to help you.
My lord, I'm not on that, my lord. Leaving aside the report, my lord. But the reason, but it's not that the complainant has been raising the issue before the FIR, my lord.
No, if you are trying to prove your innocence or show your innocence on the basis of this report.
No, I'm not. This
it
is
will not
only.
Come to your rescue
No,
it
I'm
is
not.
After the FIR.
My lord, this is one of the issues.
So
Then, and what happened, my lord, in after the FIR?
Oh, sorry, this is before the FIR, not after.
My lord, because this series of events has been continuing, and I've been working, my lord, NIT, but I've been allotted a work order way back in 2012, my lord. At page 39, my lord. Just I've been carrying on, but because.
Now the construction is completed.
But as far as it's been completed, the bills have been released, my lord.
There remains no imminent danger of anything.
But as far as no one. As far as my construction is concerned, my lord, I've completed work even after the lodging of the FIR with the supervision of the concerned officials, my lord. And my bills have also been released, my lord. And thereafter, what happened, my lord? The police have already, the bills, my lord, your lordship will find at page 46.
But then, you see, retention of bill, payment of bill, what it has to do with this?
Even in the last occasion, my your lordship has to give a completion
certificate. The query of this court still remains is that if you have completed the work. When did you complete the work?
In 2022, my lord. This is the
so even after this FIR also,
my lord, I've been allowed to
proceed.
My allowed to proceed. By the
nobody came and then you completed the work.
I have completed the work.
Is over.
Work is over.
So that risk is also over.
My lord.
The risk which has been alleged in these things or the thing.
It may happen again, my lord, that I don't know, my lord, because the area is prone to rainfall. It may happen again if, my lord, the rainfall occurs. As far as my completion work is concerned, it is completed, and there are other construction which has been carried out again by the FCI that I'm not.
No, where you do not have a hand, you are not supposed to be responsible, isn't it?
Yes, my lord.
We are concerned about this FIR.
Yes.
And then how do you say then if there were more than one contactors, then how do you say that is against you?
But that's what and in what happened after the lodging of the FIR, there's also been a final report by the police that this happened because of the rainfall. I filed in my additional affidavit, my lord. The lordship goes to the additional affidavit filed on, my lord, in April 2024. Actually, lordship got it. Additional affidavit, my lord. Actually, lordship got it.
Yes.
Your lordship may come to page 8 of the additional affidavit. This is a story what happened after the lodging of the FIR. Police has given the final report, my lord, and it was put up before the court. At page 8, my lord, annexure A of my additional affidavit.
Yes.
Yes. My lord, CR put up today, seen and perused the original FIR dated so and so, lodged by the informant so and so, and registered to the pay scale against the accused, contractor, engineer, manager, and others FCA. The case is registered in the general provisions to expect to filing a filing report. Thereafter, my next page, my lord.
Yes.
Seen the final report dated filed by so and so in connection with against the accused person Sri Jiten Gogoi. Somebody else was implemented, my lord, Jiten Gogoi.
You are not Jiten Gogoi.
I'm not Jiten Gogoi. Prayer of the eye of discharging the Jiten Gogoi is allowed and accused person discharge is discharged from liabilities of the case. Earlier they've implicated Jiten Gogoi and now they've seek for the discharge.
Who is this Jiten Gogoi?
Well, I don't know, my lord. It's up to state to answer.
Yes.
And then a notice issued as to why this affair should not be accepted. Notice issued to the complainant was the final report should not be accepted. And thereafter, again, next page, she has filed an objection to the said final report. Page 10.
Yes.
CR put up today, complainant Dr. so and so has filed a protest petition in connection with the final report submitted by the IO in the incident case. Since the protest petition submitted by the complainant object to the FR submitted by the IO and peruse the same, I am satisfied with reason given in the protest petition in objection to the FR submitted by the IO. The court hereby directs the OC Tura to conduct further investigation in the incident case registered as Tura PS case number so and so. Send a copy of this order. Then like a re-investigation was ordered. I don't know who Jiten Gogoi was. He was discharged.
So you are not connected with these things. This
is the same FIR, my lord.
That is same FIR.
My lord. When the final report was produced, even the reason, if as far as my as my instruction, my lord, the report also states that the collapse, all the sliding of the walls, or it's because of the due to heavy rainfall.
Now, if it is an FIR,
my lord,
then why the name of only Jiten Gogoi was mentioned then?
Man, that is up to the state to answer. I do not know who Jiten Gogoi is. Is not associated, is not our employee.
Then how do you know you are an accused here?
Man, that's what, my lord. After the filing of the final report, again a fresh re-investigation was required. Therefore, I have been called to answer. Then I have been made accused. That is
when you were called. When did they call you?
Well, somewhere back in 2023, my lord.
That means after these things was.
Yes, after these things, my lord.
Where is that thing? Just give us the details. How can that be done?
My lord. In my petition, my lord.
Initially, they may make one accused.
My lord.
They investigate the matter against one accused. Then they find that there is nothing. They submit FIR. FIR was not accepted.
Not accepted.
Court directs for fresh investigation. At that stage, they call you.
At this stage,
and then they make you.
Then they made an accused. But now coming back to the charge sheet, my lord, the way and the manner in which that I have been made an accused, my lord. That's also I have been annexed, my lord. If your lordship may peruse the.
No, but then when did they call you? You do not know anything.
We took an anticipatory. They called around page 66. Sorry, madam, page 65.
Anyway, where is the charge sheet? Just take.
In the additional affidavit, madam.
Yes.
At page, it starts from page 11. Now I'll read the charge sheet, madam. The way
yes, just read the relevant part.
Yes, madam. Page 14, madam.
Yes.
Madam. I shall also got it.
Yes.
The brief story of the case is that on so and so, an FIR was received from Dr. L.C. Sangma, so and so, to the effect that the large-scale construction work at the rear portion of the FCA Godown had involved massive mud filling to the tune of above 9 meters, along with inferior construction of RCC retaining boundary wall carried out by the contractor, engineer, supervisor, and the concerned manager of FCA under the protection of the implementing agency, just above the complainant's land without any water outlet, ensuring direct flow of the rainwater. The mud, slush, and the dirt were being collected in the FCA Godown have direct flowed into our compounds, thereby causing huge loss to their property, including damage to fixtures and fittings. The newly constructed warehouse on the loose soil has developed cracks, and the soil on which it has been built is eroding. Thereafter, the RCC returning boundary wall of the FCA complex has developed cracks, tilted, and collapsed into their property on 19 July 2020. This has resulted in the shifting of mud, destructing the property, and therein, if no action is taken, it would result in a big catastrophe, including loss of human lives and washing away of the house structure. Hence the case. Yeah, my lord. During the course of investigation, the PO was visited and the rough sketch plan of PO was drawn. The statement of the complainant, so-and-so, was also recorded under 161, where she states that on 19 July, the under construction retaining boundary wall of FCI Nazim Bazar collapsed. Thereafter, rainwater lodging along with the lines, mud and dirt flowed towards her house, which causes damage to her property. Similar types of landslide incident also occurred on 20 March 2015, 12 July 2019, and the complainant filed the complaint to the concerned authorities of FCA. But the necessary measures were not taken and the construction was not carried out properly. Thereafter, the retaining wall developed cracks and the collapsed wall towards the adjoining areas of the local residents' property, which has caused damages and affected to the locality of residential houses due to the mudslide and direct flow of rainwater into the house of the complainant. Further, the statement of the complainant was also recorded under 164 CRPC. Well, this paragraph, perhaps it will be most relevant to the third one. In the course of the investigation, visited the Central Public Works Department and recorded a statement of Shri Vishnu Prasad Diori, in charge assistant engineer, under section 162, where he states that the mudslide has occurred on 19th January due to incessant rain and water being collected. Due to incessant rain and water being collected along with the construction site of retaining wall, as a result of which retaining wall of the FCI godown collapsed and heavy mudslide occurred and flowed the mud along with the dirt, water towards locality, residential houses, which has affected their property. Now here the engineer itself says that this has happened due to the heavy rainfall and not under any inferior material. Their statement has been recorded. During the further course of investigation, Sri Nogan Chandra Boraman, that is me, my lord, son and so resident so appeared at Aramal PS on behalf of contractor Sri Sonasa Marbanang on being granted interim bail in the Honorable Court of Special Judge Westgar Hills. He was arrested and released on bail bond on being produced 2 sureties as the order of the passed by the Court of the Special.
You are not the contractor. Shalansong Marwan was the contractor.
The authority letter has been given, my lord, which I have also annexed in my petition, my lord, that all the works.
Complaint was against the contractor. The contractor has been this thing. Apart from you, how many accused are there in this case?
Well, only I have been narrated as an accused, but that is not.
Contractor has not been made.
Contractor has not been made party.
None of the official of FCA has
no,
been
FCA, nor the officials of the CPW has been made a party. It's because only reason that we have taken an anticipatory bail, and they very perfunctorily I have been made an accused in the case. Well, here, my lord, he was arrested and released on bail bond on being produced 2 sureties as per the order passed by the Court of Special Judge Tura. He was examined and revealed that he has taken care, my lord, here, my lord. It is their statement, my lord. He have taken care and supervised all the works, construction of storage of godown so-and-so Nazim Bazar, including the construction of boundary retaining wall work order for the construction was received on December 20, 2012, and the construction was started from the next year 2013. In between 2 to 3 years, have been gap and construction awaited due to non-release of funds. The construction have been completed and all pending bills have been released on the last year 2022. Further, he produces authorization letter for work, construction of storage godown of so-and-so, Meghalaya to present him and act on behalf of the proprietor so-and-so, relating to any kinds of correspondence with the department, receiving instruction from department, collecting and receiving of letters, bills, checks, and the department addressing to the executive engineer so-and-so, Mahmudi Madhanma. Considering of the prima facie case under section, so as being as.
What is 290?
Malal here, Malal come. 290 is Malal public nuisance. 206 is fraudulent removal of concealment of property to prevent its seizure. 427 is mischief.
How 206, how it applies here?
Well, that's what, Malal. I'll read the definition of the section which has been attractive.
Let us come with 290, just
yes,
start with 290.
Punishment for public nuisance in case not otherwise provided for. Whoever commits a public nuisance in any case not otherwise punishable by this code shall be punished with fine which may extend to 2 or 200 rupees.
Where do you get the definition of public nuisance?
Where's
where is that? It should be here.
Well, in the charge sheet.
Where is the definition of public nuisance in this IPC? If somebody can be punished, What can be termed as public nuisance?
The definition, my lord.
You see, public nuisance can be something. You play music loudly, that can be public nuisance.
Yes.
Okay,
Yes.
you throw garbage on somebody's house, that is also public nuisance. Now, here for public nuisance, where do we get the definition?
But that's what, my lord. Nowhere it's attracted in this case. In my case,
No. If you let us first see where is public nuisance.
my lord.
Where is that? Is it provided? Yes, Mr. Sheikh. You are paying for the state. Yes. Where is public nuisance? And if that is the case of public nuisance here, what is the public nuisance here in this case?
Lord, section 268 IPC.
Yes. Yes.
I'll read, brother. A person is guilty of a public nuisance who does any act or is guilty of an illegal omission which causes any common injury, danger, or annoyance to the public or to the people in general who dwell or occupy property in the vicinity, or which must necessarily cause injury, obstruction, danger, or annoyance to persons who may have occasions to use any public right. A common nuisance is not excused on the ground that it causes more convenience or convenience or advantage.
When this charge sheet was filed, what is the date of the charge sheet?
The charge sheet.
When did you complete the work? Give us the thing.
My lord, yes, my lord. I have completed the work in 2022, my lord. And in this, your lordship acquired this when it took a producer completion certificate.
Can you give me the list of those things? Shall I when this?
My lord.
Just give me the dates on which the charge sheet was filed. When this?
My lord,
you completed the work.
The FIR, my lord, starting from the FIR, my lord. The FIR was in the year 2020. My lord, I have completed my work in 2022.
Charge sheet 25/9/2023.
2023.
After you completed the work.
After completion. This is the, my lord, completion certificate given by the department themselves.
You constructed a godown.
My lord. Was closed on 12/2/2022, my lord. The certificate is issued by the department, my lord. My lord, the next section is 206.
Come back to 268.
My lord.
Section 268.
My lord. 268, my lord, public nuisance, my lord. Is it a case that I've carried out my work as per the instruction of the department? A tender has been floated. I was given the award contract, and in the FIR, my lord, they have been given contractor, supervisor. It's not that I have carried out the work on my own under the supervision in the charge.
This FIR was lodged in 2020.
My lord.
Now, if there was any danger, there was any danger of causing injury or annoyance to the public,
my lord,
the normal assumption is that the administration will not allow you to carry on that work any further.
My lord.
But then here you work, you complete the work, and after the work they file a charge sheet. They make only you are the.
Even
yes,
there was a final report before to that, stating someone then
somebody else
they've been discharged.
Just because court did not accept you, then they drag you.
Then they drag me. I've been made a scapegoat, man. All I can say at this stage, man.
Yes.
And my lord, if at all, the private respondent, complainant.
Please repeat the date of the FIR, please kindly. 21/7/2020, isn't it?
21/7/2020.
Yes.
And then there was a final report to that effect, Malot, which was it.
When is the final report?
Malot, on final report was filed on 21/3/2023.
It was filed on 21/3.
Sorry, Malot, no, Malot. It was filed on 27/10/2022. Malot, annexure page 9 of my additional affidavit.
27/10.
Malot, going by the order of the court, Malot.
But then, do you have a copy of the FR?
Not the statement.
Mr. Sheikh will give us the date of the FR final report when it was submitted initially.
13/10/22, Malot, as per the order of the court, Malot, page 9, Malot, of the additional affidavit.
As per page?
Page 9, Malot.
Of the additional affidavit.
By the order dated 27/10/22. Here
it says FR dated 13.
Yes, Malot, that's in the final report number so and so, date 13/10/22, filed by the.
Now, one thing is very surprising.
Malot.
You completed your work on 12 February 2022.
Malot.
Now, FR was submitted after that.
The final report, yes.
The Just Because Court did not accept it.
Malot. The complainant did not accept it.
They again reinvestigate and
Malot.
they find you guilty.
Malot. Not
very
the.
interesting.
Very interesting. Only me, Malot.
Yes, what are the other sections for 206? What is 206?
Malot, 206, Malot, fraudulent removal, 206, Malot, yes. If I may, Malot.
Fraudulent, yes.
Yes, fraudulent removal or concealment of property to prevent its seizure as forfeited or in execution.
Not at all applicable here, is
Malot.
it?
And
even
then,
if you go by the charge sheet.
Malot, even if I go for the charge sheet, Malot.
Yes.
Charge sheet, Malot, then 427.
What is 427?
Malot, mischief causing damage to.
Mischief.
Malot,
what are the mischief?
But that's what, Malot, there's no such statement in the charge sheet.
What is the definition of mischief?
Mischief. 16.
No, mischief.
Mischief.
Mischief comes 425. What is more? Just comes. Read IPC 425. What is called mischief?
Mischief 425, Malot.
Yes.
Whoever with intent to cause or knowing that he is likely to cause wrongful loss or damage to the public or to any person, cause the destruction of any property or any such change in any property or in the situation thereof as destroys or diminishes its value or utility or affects it injuriously, commits mischief.
So it is, there is nothing as such here it is,
Yeah,
isn't it? You have not done anything which has diminished value or utility or anything.
No, Malot.
There is not the
No.
So 427 also apparently not.
427 even.
Okay, and then?
432.
Yes, what is that 432?
Obstruction to public drainage, Malot.
Causing inundation. Public drainage.
Malot, yes. Public drainage. Mischief causing inundation of whoever commits mischief by doing any act which causes or which he knows is likely to cause an inundation or an obstruction to any public drainage.
Yes, it means there has to be an existing drain. Say supposing there is a municipal drain.
Malot.
You put obstruction there.
Yes.
Okay, which causes inundation.
Malot.
Okay, drain overflows causes this. So here it is not a case that where there exists a public drain, we have blocked it.
That's not a case here.
Public drain means a drain is constructed by
Before.
an authority.
My lord.
Just because a private individual makes a drain, it will not be public.
My lord.
Isn't it?
Yes, my lord.
And even if it is a private drain also, there has to be a drain at least.
My lord.
So you have not entered any one compound, isn't
No,
it?
my lord. It's sliding, my lord. It may FIR
Yes.
as well as charge it. My lord.
So apparently, what do you call it? 432 is also not coming.
Not connected.
Then what else?
My lord, 406.
What is that?
My lord, criminal breach of trust, my lord.
What is the trust of this thing?
My lord, yes.
What was the trust which you have breached?
The definition of trust, my lord.
Criminal breach of trust. You read 406 will be this
Yes,
thing. What you are entrusted and which you have
Yeah,
betrayed the
but
trust.
it has to be taken with 405, my lord. I'll read. Criminal breach of trust, my lord, the definition. Whoever, being in manner entrusted with property or with dominion over property, dishonestly misappropriates or converts to his own use that property, or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mode in
Yes,
which.
that is enough.
My lord.
More than enough. Yes.
And the 406 punishment for criminal breach of trust.
Yes. All right.
And my lord, surprisingly.
Anything more you want to say?
34, my lord. Only last option, my lord, whether this is a case where, my lord, I have completed my work under the supervision of the authorities. It is not that I have done on my own. And here, my lord, the complainant have not filed any suit or any injunction to stop the work. It's the FIR, and in the FIR, I have not been named and accused, my lord. As a lordship, there is a final report arraigning someone else, and after the final report, a re-investigation, and without very perfunctory in this charge itself, they have investigated the engineer, my lord, but they have stated that it is due to the incessant rain that the sliding happened, and it was corrected accordingly. I have completed my work. That is my humble submission before this wonderful court.
Yes, Mr. Sheikh. Mr. Das,
My lordship.
Mr. Sheikh is a bigger role than you. We'll come to you when it's.
I'm the victim otherwise.
You are the complainant. That is all right. The investigation is by the state. We'll first see what state is.
My lordship.
My lord, why you have
Come this side. Come this side. Yes.
so far as his involvement, lordship, in the final report, lordship, that is at page 14, last para, lordship, during the why he has been
Page 14 of
page 14 of the additional affidavit, lordship, where the charge sheet has been unclosed, lordship. How did he come to picture, lordship? Why he has been arraigned as an accused in the case, lordship?
Yes, please.
Last, lordship, that during the course of investigation, Sri Nagan Chandra Boro,
You are reading page
1 for, lordship.
1 4.
1 in the additional affidavit, lordship, where the charge sheet has been.
Yes.
That is with regard to his involvement, lordship. Why he has been arraigned, lordship.
Yes.
During the course of investigation, Sri Nagan Chandra Boro, son of so-and-so, permanent resident of so-and-so, this so-and-so, appeared at the RML PS on behalf of the contractor, Sri so-and-so, on being granted interim bail from the Honorable Court of Special Justice, West Garhipura. He was arrested and released on bail bond on being produced to sureties as per the order passed by the Honorable Court of Special Justice. He was examined and revealed that he have, this is very important, lordship, he have taken care and supervised all the works.
So his work and his supervision will override the work and supervision of the department.
Lordship, construction of storage go down of so and so capacity so at Najing Bazar, including the construction of boundary wall. Work order for the construction was received in December so and so 2012, and the construction of works was started on next year 2013. In between, from 2 to 3 years have been gap, and the construction awaited due to non-release of funds. The construction have been completed and all the pending bills has already been released on so and so. Further, he produced the authorization letter for the work construction of storage ground of so and so capacity for FCI Tura so and so to represent him and act on behalf of the proprietor Sri MS Sorole Mansan Marwanian,
yes.
relating to any kinds of correspondence with the department, receiving instruction from the department, collection and receiving of letters, bills and checks from the department, addressing to the executive engineer Guwahati Central so and so. Although the work
you have read out the thing.
Yes, Lordship.
Paragraph.
Yes.
This just tell us this where there is a mention of commission of any crime in this
Lordship,
paragraph.
Lordship, that is Lordship, that so far as his involvement, Lordship, because my friend has raised that, yes.
See,
That-
it is not that he is not saying that he has not constructed. That is not at all his case.
No, he is saying that I was not in because I am not the
He is-
contractor
he
and
is
this.
not running away from the picture. So
Yes.
you do not have to say.
Yes, Lordship, that.
The paragraph you have read out just now, it's all
And-
right.
and so-
Just show us in this paragraph, this entire charge sheet, where is a mention of commission of offence by.
My Lord just recently has read out all the provisions of section, Lordship. I cannot improve.
No, you see.
I cannot improve, my Lord.
No, we are not telling
yes,
you
Lordship.
to improve anything.
Yes,
we are
Lordship.
just saying, Mr. Sheikh, just point out where the charge sheet says that he has committed any illegality.
Lordship is right, Lordship.
That is enough, Mr. Sheikh.
Lordship,
Thank you.
I cannot
Thank
improve.
you. You do not have to say anything. All right.
Case
Yes,
of the
sir.
provision, my
You are-
Lord
you
has
are-
already
This
read out
court
all the.
appreciates a fair counsel.
Yes, Lordship. I
Thank
cannot
you.
improve.
Yes.
That is only with regard to his involvement. He is
Yes.
saying that I was not involved. I am
That-
not the
see,
contractor. Yes.
He did not say he
Yes.
is not. There is Mr. Smith never argued. He never said that I did not work. He is quite fair. He did not bring forward his contractor before. He
My
did
lord,
not. He
everything
did not use his contractor as a shield. He said, "No, I did it.
Everything is.
I did it on behalf of Sanction Marvania." But then his thesis is that he has not done anything wrong. So far as your charge sheet is concerned, there is not even a single word which implicates him or says that he has committed any wrong.
My lord, everything is.
And
before
how
your
can you
lordship.
how can you basically overlook the government officials and come and catch him where he was working as an agent of somebody? Anyway, Mr. Sheikh, you are fair. Thank you. Yes, Mr. Das. Now comes your route. Your route.
At the very inception, my lord.
Yes.
From his petition only, I would like to point some relevant paragraphs, my lord. Page 6, my lord. This is 3, this would be 3C,
Just a minute.
my lord. Page 6, my lord.
Yes.
C, my lord.
Yes.
The said firm had authorized the petitioner, who is an employee of the firm, to represent the firm relating to any kind of correspondence with the department in executing the said work by the authorization letter 7/12/2012. So the entire issue started right from the period of 2012, bearing number so and so. The said authorization letter was also forwarded to respondent number 2, and the petitioner, this is important, my lord, the petitioner had commenced the said work under the instruction of the firm as well as the guidelines laid down by the CPWD.
So
I
he
understand,
is not
my lord.
denying that.
Yes,
There
yes,
is
he is
no
not
at all.
denying. He is not denying the fact that he is working under the instruction of the firm as well as guidelines laid down by the CPWD. But the fact remains, it's a considered that he has constructed the work, my lord.
And
That is a
we
fact.
admit, we consider also
Even
which way-
today
which way-
also, if my lordship appoints any commission, my lordship, that commission will give a report that the situation, because he has got a clearance certificate from the department, he has got the money also, but the situation has not, my lord, he has not rectified anything as has been claimed by him. That is also, my lord, amounts to conceding of the material fact that there was a wrong done before, my lord. At page 12, grounds, point number 2, my lord. Respondent number 7, following the lodging of the FIR, has concealed the immediate steps taken by the petitioner and the respondent authorities in assessing and ultimately in successfully rectifying the damage caused. So damage was caused, my lord, to me, to my house. I am the victim. That is why I am the informant of the present
What
case.
are the
I
damage?
lost.
What are the damage caused? And what is the criminal culpability here? See, it is
My lord,
every damage caused by the construction would it become a crime under IPC?
No.
Now, if something is persisting, something is not modified, even in spite of protest being lodged, then it may constitute. Otherwise, just because if some damage happens accidentally, can you make somebody responsible?
My lordship may kindly see one aspect. This is a damage. This is a situation which has not arisen for the first time. These communications, these problems, this, my lord, damage to the property, my lord, there is loss to the property, as well as, my lord, the threat to the life of the people living in the vicinity.
What is the loss of property, and where is the mention of that in the charge sheet?
My lord, firstly, he has not come and challenged the charge sheet, my lord, because this initial...
It is not required. Apex Court has made it very much clear.
Clear, my lord.
So, it is charge sheet is not required, even during the pendency if charge sheet is filed. Thus, it is not required.
But prima facie,
take cognizance of the charge
prima facie, the FIR, my lord, it is clear there. If in the FIR itself, it is clear about the offence that has been, my lord.
This, but then charge sheet doesn't say so. You say FIR is not a conclusive proof in a criminal trial. FIR is basically a piece of paper or information based on which investigation starts.
Yes, my lord.
Now, at this stage, charge sheet becomes important. If you go by the proposition of law laid down in Bhajanlal's case,
yes,
we'll just go and accept it.
What
accept
enmity do I have with this person? Nothing.
See,
why? What maleficeness I have to commit with this particular person? Nothing. My only problem is, my lord, a contractor, upon repeated request, is constructing something which is causing damage to my property. In spite of the fact that, my lord, he is having the knowledge that by doing so, he will cause damage to my property. Then, my lord, there is the culpability.
What are the damage caused?
That is, they themselves are accepting the entire...
What are the damages?
My lordship, may kindly come to the FIR, my lord.
You just broken one piece of glass of your window pane. You say damages and specify the damages.
And
you say your
my
thing has been
entire house is, my lord, the rainwater, the sludges, the mud, and entire thing is happening because of this construction, because of dumping of, my lord, illegally dumping of loose soil in the property which is adjacent to my property.
Where is the report of those damages?
My lord, there are in fact the petition itself. If, that I'll place. I'll satisfy your lordship to that extent, my lord. Firstly, page 24 is my FIR. If I may kindly
see, Mr. Das, you see, like the FIR charge sheet supports it.
My lordship.
We are talking about acceptance or resistance. At your instance, if we accept this FIR, oh sorry, have this charge sheet in total, will it make out a criminal case? That is the question. And if you say yes, just show us with the charge sheet where there is a mention of any wrongdoing.
My 161 statement was recorded.
You are a senior man. You are a matured lawyer. You will definitely not stand up to argue a case chart for the sake of argument.
I am not putting emphasis only on the FIR, my lord. My 161 statement was also recorded. My 164 statement was also recorded. Those entire records are there to be perused by the learned trial court, my lord. And, my lord, this is a present stage of the case is framing of charge, my lord, because he has already appeared before the court below, my lord, as per his own affidavit.
It doesn't matter.
Yes, my lord. Now, my lord, my lordship may kindly come to page number 29. That is letter from the DC, my lord. Page 29. That was also way back in the year 2015 itself, my lord. Complaint against contractor who is constructing FCI godown located at Najiang Bazar, Tura.
He was not the contractor. He was not the contractor.
He was the contractor, my lord.
He was not the contractor.
He has
one Mr. Marwani was the contractor. He was never a contractor.
Let him show, my lord, that Marwani contracted the
that is what
wall,
the
my lord.
Says, Solenson Marwani. That is what this contract was never awarded to him.
Yes, my lord, but he was
he executed the work. That's a different thing.
My lord,
now, if you talk about 2015,
that is the lapse of the, my lord, state instrumentalities for my suffering, that this contractor has not been made an accused. The entire department officials, my lord, that is 319 stage, my lord, that may come, my lord, because public money has also spent, wherein, my lord, it is a case of loss of public money also. And investigation has been
that goes-
investigation has been done, my lord. It was done perfunctorily because, my lord, my rights have been affected, my lord. I don't know about the accused person's rights,
See,
my lord.
the main thing is that it seems you do not have any grievance against the FCI officers.
No, my lord. I have.
No,
In
but
FIR,
you
I
have
said.
not raised any grievance. It
I
appears
raised,
to
my
be-
lord.
Well, you are just satisfied to prosecute the
No,
complainant.
no, that is not my case, my
Who is
lord.
not even directly connected with the work.
That is
He
not
indirectly he comes.
No, my lord, that is absolutely not my case. In the FIR, I have specified who are the instrumentalities who are responsible for this damage. Then, my lord, the final report was submitted. Then I again, after receipt of notice, I raised my voice. I submitted my protest petition. Then, my lord, the reinvestigation was open. Again, then, my lord, only one of the accused person was charge sheeted, leaving apart the other accused persons, my lord.
So what have you done for that?
My lordship?
What have you done for that? Or there is no remedy available in law?
319 stays, my lord. That is the honorable trial court will see.
After the trial commences. Only after
During
the trial.
my lord, at this stage, what can I do? I have never mentioned about him, my lord, in my FIR. I mentioned about the officials, as well as I mentioned the name of only the contractor, not the name of the contractor. It is the investigating agency who found out who was the contractor who was doing the work, who had done the wrong, and that is why they might have submitted the charge sheet. But my FIR, I have not named anyone that he is responsible. I said contractor who was doing the construction work, my lord. I had said these were the authorities who are behind the construction of illegal construction of this work.
You have named. You may not have named any officer individually, but then you have said in your FIR that these officials of FCI also
My
are
lordship.
responsible.
My lordship. Then now,
say for a citizen, say supposing if he files one investigation whereby he pinpoints allegation against someone, and the investigating authority overlooks it, do you want to say the complainant is helpless and you will have to wait till the stage of section 319 CRPC to implicate them? Otherwise, the complainant has no.
my lord,
remedy
I already.
available.
No, my lord. I already filed my Naraji petition. I filed my Naraji petition.
That is against the acceptance of effort. Anyway, it's all right. No
Now,
problem.
my lord, page 29.
Yes, we have seen it. Complaint against contractor who is constructing FCI.
Yes, my lord. Second para, my lord.
Yes.
In view of this, you are kindly requested to stop the construction work on grounds of public nuisance.
Yes.
And let the contractor sign a social agreement with the complainants to take measures that rights of citizens are not affected. Whether he signed any agreement, my lord.
So if it is not signed, will it constitute a criminal offence? Let us assume he has not signed. What criminal offence he has committed?
Yes, my lord. If it is not...
See, Mr. Das.
I understand, my lord.
Maybe civil remedy in certain matters.
Yes, my lord.
Resorting to criminal action may not give you the relief which you expect. We can understand as a citizen your concern, your property, if it is damaged, you would definitely like that it should be, you see, like it should be compensated for the damages, isn't it? Or the wrong, whatever has been done, should be corrected.
My lord, this issue started way back in the year 2012, as I said, my lord. Time and again, persistently, I am approaching different authorities that this issue is happening because the contractor is continuing with the construction work, dumping the soil in loose soil in the area which cannot hold that soil, my lord. And finally, when my entire property was damaged, the fall today also, in today's date, my lord,
he did not take to stop this construction. They did not take any steps to stop construction. Though you said that from 2015 onwards,
my lord, these are the communications.
Now you have written the authorities did not act. Their work went ahead. You did not approach any other authority, including the judicial authority.
Work was stopped, my lord.
Where? Work has been completed in 2022.
Debris is still lying there, my lord. My property, my plot of land, my lord.
Well, it may be of different work order, I don't know.
It's all right.
They have not placed any material before this honorable court because it is the duty of the petitioner to show that yes, prima facie, my FIR does not disclose any case. I am not saying that prima facie does not make out a case.
No.
Even Honorable Apex Court has used the word disclose, not make out, my lord. Because it is when the machinery started, my lord, criminal machinery started and charge sheet was submitted, my FIR attained finality, and then it is the duty of the trial court to see whether the offence has been committed or not. When my FIR is, my lord, discloses the offence, my lord, not prima facie made out even, my lord. That is one of the judgment, if my lordship allows me to place, my lord.
No, you are allowed to place any judgment you want.
My lordship.
Here, you see, the matter doesn't end with your FIR. There is a charge sheet.
Charge sheet.
There is a charge sheet now.
Which authenticates my, as on date, my lord, which authenticates my disclosure in the FIR, because they have challenged my FIR.
It not at all. It doesn't implicate any of the government officials.
That is
so doesn't authenticate
that
anything.
is the lapse of the investigating agency, that they have not made the officers.
Your persistence to pursue prosecution of the complainant here basically points out nothing. You want to victimize him. Otherwise, he is nothing. He is a mere an agent.
I don't want to victimize him. I have
he was working under a master.
My lordship.
Now you have forgotten the master. You are forgetting all the superior officers who can be directly held responsible.
I don't supposed to know who is the master and who is the agent. I am not supposed to know under whose authority he is doing. I just know that this is the FCI go down wherein he is illegally raising certain construction, my lord, and that is why before my lordship.
If you say you are not supposed to know, that is not correct. In a criminal proceeding, you are supposed to know, and you must ensure that only the person responsible is convicted. If you say if you are not supposed to know, then you are not speaking responsibly.
No, my lord.
Because
other authorities, my lord. Other authorities.
No, but then you said that you are not supposed to know it.
No. The contractor.
FIR,
the contractor,
with
because
the filing of the FIR, your responsibility is discharged.
No.
Now what happens? It is not your authority.
No, my lord. The contractor is illegally constructing, my lord. I know that, and that is why I filed Narazi petition, my lord. That in spite of the fact that
if contractor is illegally constructing,
my lord,
why the government department is not stopping him? Your construction was not.
My lord, he has submitted before this honorable court communications from the government on being initiated by my.
At your instance.
Yes, my lord.
But then these are mere writing.
It was stopped. It was stopped. Then, my lord, they kindly see, without completing the entire work, he got the completion certificate. He got the government fund released. That is, that will make out a different case altogether now.
Can we go and...
They took completion certificate when, my lord?
See, completion certificate was given on...
This year, 2024. And now, till now, the work has not been completed. Is that not an offence, my lord? Is that not a misutilization of public fund?
This is a government.
The government fund they are misutilizing without doing proper work, my lord. This is happening not in this particular case only, my lord. In numerous cases, this is happening.
That becomes a subject matter of public interest. We are not at all.
Yes, my lord. I am limited. My submission is limited to this particular case, my lord.
Okay.
And my case is that, my lord, my FIR prima facie discloses a commission of an offence, my lord. Because, my lord, a particular property is constructed in such a manner which, my lord, endangers the life of the person living near the vicinity of that area. My property is being damaged, my entire family is suffering because of that. And that is why I raised this FIR, my lord. I filed this FIR that the contractor is constructing the work illegally.
See, the problem is that you say from 2015, you are remaining under danger. But then, almost 10 years, nothing has happened, and you have not taken
wall collapse, my lord. The entire wall collapse.
Please wait for the court to complete this.
My lordship, my lord.
And there is nothing on record to show that you have taken any concrete step to stop the construction or whatever you say illegally was going on. There's nothing. Have you approached any civil court for getting injunction against the work? If you say that there was an imminence of danger, that 10 years nothing happens, how this court will believe that there is the imminence of danger? Now the presumption will be against you. You will say there is no imminence of danger.
Yes, my lord.
The fact remains you have not done anything to stop the work. On the contrary, there is a certificate which says the work has been completed. We are concerned with the record. You see, we are not concerned with things. We can understand that in 482 we have limited power. We will not go into these things. We will confine ourselves to the charge sheet. Or as you say, with the FIR. Just
FIR.
Nothing more than that.
My lord. Then, my lord, page 31, my lord, may kindly see 19 July 2023 correspondence from the Commissioner and Chairman.
Yes. This is Deputy Commissioner.
My lord, Deputy Commissioner, Chairman, District Disaster Management Authority.
Yes.
Manager, FCI.
Yes. But as you say, just read it.
My lord, with reference to the subject cited above, I am to say that mudslide has occurred on so and so due to incessant rain below the FCI godown Tura, where the locality of the residential house below the FCI godown Tura has been affected. The boundary wall of FCI godown Tura has been damaged due to mudslide and may further affect the house located below the FCI godown. Last year, heavy mudslide and had occurred the same area where the residential houses below the retaining wall of FCI godown Tura was badly affected. In this connection, you are hereby instructed to take immediate action and take further technical advice from expert and put a permanent solution to the immediate.
Yes.
Then, my lord, what actions he had taken? He had done nothing, my lord. Then page 29, my lordship has seen.
If we go and appreciate all those things, where will come?
No, my lord,
Where you take
these are not the subject matter of the, my lord, documents placed before the investigating agency. These are the documents submitted by the petitioner at the time of filing of this case, my lord. Then what is the authenticity of these documents, my lord?
You are placing reliance on this. This court is very, aware, or rather well aware about the fact that at this stage, the court should not take into consideration the version of the complaint. It is the prosecution story, which is the sole material basing on which this matter has to be decided. Now, whatever his story is, we ignore it. We confine ourselves only to the prosecution stories and just see whether case is made out.
Then, my lordship may kindly see at this stage, my lord. My lordship may kindly see the FIR filed by me and the sections under which he has charge sheeted, my lord. My lordship has seen the definition of mischief. If I may be allowed to take my lordship again to the definition.
Please,
my lord.
Yes, no problem. $425.
My lordship. Whoever.
Yes, please.
Whoever with intent to cause or knowing that he is likely to cause, knowing that, my lord. Since 2015, he knows that this is happening, my lord.
Only he or many others.
Then, my lord.
See, this communication, if you place reliance on this publication at page 29, page 31 now, these are the communication which are made to the Chief Executive Officer, Tura Municipal Board. Now, that way you can say that CEO Tura also knew that.
So then, my lord, do I have to accept his argument that because of the fact that, my lord, the accused persons who ought to have had been made an accused person in this particular case were not made an accused, he gets the charge of his liabilities?
No.
Do I have to accept this argument?
Definitely not. Definitely not. There is no question. Even if court accepts this, you are not supposed to accept this. It is not for you to accept.
My lordship.
Yes.
So
there
that is
no question. There is no question.
That is a question I put to
just
myself, my lord.
Just because some other person who should have been joined as accused here has not been joined, cannot be a ground for question.
Absolutely, my lord.
Definitely
that question
not.
I put to myself, and that is the answer I.
But then that is because of your argument. Because where you are holding him responsible. You see, that shows that you are ready to give clean sheet to the officials, you are ready to give clean sheet to the main contractor, but then you want him.
I am not the authority to give clean sheet to the contractor, my lord. I am not the authority to give clean sheet to the other officials, my lord. My concern is that an offence has been committed. I intimated the same to the officer in charge of the concerned police station that this contractor is constructing something which is an offence under Indian Penal Code, and I am entitled for protection. Yes, but at the same time that makes him liable for punishment also under the IPC, maybe a fine, my lord. But an offence has been committed under the,
No, offence is
as per me, my lord, as per me. But investigating agency, they have, my lord, in what manner they have done the investigation, I don't know. Even I cannot direct the investigating officer to conduct the investigation in a particular manner, my lord. But my lord, they have done some investigation and submitted a report.
Now,
when I received the notice from the honorable court that against my FIR, final report has been submitted, I again approached the honorable court below, said I have objection, and I submitted a Naraji petition, my lord. Then, while acting upon that, my lord, the honorable court directed the investigating agency that the final report cannot be accepted and directed for a further investigation. Definitely upon finding some material in my Naraji petition as well as my FIR, and that is how, my lord.
Yes, and your objection was against acceptance of FIR and discharge of one person called Jibon Roy.
No, that is not my prayer. That is not my prayer, my lord. That is the prayer of the investigating officer, my lord.
Whatever it is, but then your
I
objection,
am not the investigating agency, my lord.
Your objection came against that FIR,
my lord,
by which the investigating agency proposed to give a clean sheet to that Jibon Teka.
Jiten Gogoi, my lord.
Jiten Gogoi. You objected.
I objected, my lord.
Now, what happened? Your objection was upheld. Matter that the investigating authority was asked to reinvestigate the matter. Now, Jiten Gogoi has disappeared. The new person has come. You have no problem with that.
I don't know about that, my lord.
Yes, all right.
I don't know about
anything
that.
more? Anything more you want to say?
One judgment, if I may be allowed to place, my lord.
What is the judgment about?
2023 4 SCC, my lord.
What does it say?
Oh, sorry, my lord. 2023 4 SCC 338.
What does it say?
My lord, para 340 page, para 7. List of books I have given, my lord.
Yes, all right. Please go ahead.
My lordship. Para 7, my lord.
Yes.
It is relying on a judgment, my lord. Niharika Infrastructures.
Yes.
Then para 13.4, my lord. Relevant paras I am placing before your lord.
Yes.
Para 13.4, may I read, my lord?
Yes.
The power of quashing should be exercised sparingly with circumspection in the rarest of rare cases. This is, my lord, normal. Yes, my lord, this is normal. I'm coming to the relevant prayer, my lord.
It is a reproduction of what has been said in the Niharika's case.
Yes.
Yes.
Criminal 13.6, my lord. Criminal proceedings ought not to be scuttled at the initial stage. 13.10, my lord. Ordinarily, the courts are barred from usurping the jurisdiction of the police, since the two organs of the state operate in two specific spheres of activities. The inherent power of the court is, however, recognized to secure the ends of justice or prevent the above of the process by securing by section 482 CRPC. Then, my lord, 13.12, my lord. The first information report is not an encyclopedia which must disclose all facts and details relating to the offence reported. Therefore, when the investigation by the police is in progress, the court should not go into the merit of the allegation in the FIR. Police must be permitted to complete the investigation. It would be premature to pronounce the conclusion based on hazy facts that complainant FIR does not deserve to be investigated or that it amounts to abuse of process of law. During or after investigation, if the investigating officer finds that there is no substance in the application made by the complainant, the investigating officer may file an appropriate report summary before the learned magistrate, which may be considered by learned magistrate in accordance with the known procedure. Then 13.
These are all settled proposition of law.
My lord.
So anything you want to show specifically here?
My lord, 13.15, my lord.
Yes.
When a prayer for quashing the FIR is made by the alleged accused, the court, when it exercises the power under 482 CRPC, only has to consider whether or not the allegation in the FIR discloses the commission of cognizable offence, and is not required to consider on merit whether the allegations made out a cognizable offence or not. And the court has to permit the investigating agency police to investigate the allegations in the FIR. So, if the FIR discloses the commission of a cognizable offence, my lord, then my lord, now my lord, para 8 for a moment. Even otherwise, para 8, page 342, my lord. Even otherwise, it is settled position of law that while exercising powers under section 482 CRPC, the High Court is not required to conduct a mini trial. What is required to be considered at this stage is the nature of accusations and allegations in the FIR, and whether the above allegations in the FIR prima facie discloses the commission of the cognizable offence or not. So, in my case, my lord, prima facie, my lord, when the charge sheet has been submitted against the accused person, my lord, it prima facie, my lord, it discloses. That is my humble submission.
That is exactly right at the beginning. This court was asking you, point out a part in the charge sheet which discloses an offence.
My lord, that is my learned.
If you say that is disclosure, show us in the charge sheet what is. Anyway, it's all.
And the, my lord, what investigation that has been done by the investigating agency, that statements, my lordship must have called for the
statement under 161.
Yes, and 164 also, my lord. It is there because my statement was recorded under section 164 also. So, my lord, that is the sum and substance of the entire issue, my lord. The position that was in the year 2020 is still the same, but my lord, the contractor has managed to get the completion certificate, get the public money released, and my lord, if now another investigation would start, my lord, that will, my lord, not only implicate him, my lord, but the other officials also, because, my lord, it is a misuse of the public money, my lord. Not only limited to my suffering, my lord, but the money of numerous taxpayers have been invested just like that, my lord.
You do not have anything to do with this at this stage.
My lord, but this is, that is why, my lord, that is why I am submitting that whether this particular prima facie discloses, my lord.
Can we direct the investigating authority to make an investigation against the government officials also involved here in this application? Can this court exercise that jurisdiction?
No, my lord, because this is the application filed by the petitioner side, and if suo moto honorable court
say if you do not accept his argument, we reject his case,
my lordship,
and while disposing we say that make some more accused. Can we do that?
482 suo moto honorable court has the jurisdiction, my lord. In inherent power, my lord, that is not a bar, my lord. So if my lordship thinks that
we can direct, we can say that on perusal of records, that it is not only the petitioner. Here, there seems other persons, those who are responsible.
And investigation has not been done properly.
Investigate and see the possibility of finding a charge sheet against them. That direction also you can pass. If
honorable court has the power, my lord, under 482 inherent power of the High Court, my lord.
Yes.
I am deeply obliged.
You are also there, Dr. Majika. You are for the 2 and 3. We will drag you there. That is what we are inquiring from Mr. Das.
The go-down was for FCI, my lord. FCI was the requisitioning authority. We were the tendering authority. We issued the tender and awarded the contract to Srolands and Marmanian, my lord. And that's why. Now, my only point of submission before lordship is that there is a difference between tort and crime, my lord. Now, tort is a civil liability, my lord, and there is a civil action is required to be taken against.
Yes,
If there is any dangerous construction, my lord, or if they apprehend anything, civil remedy is, in my humble submission, proper remedy rather than filing a criminal case against this. That's my short submission.
So you want to say that there is no criminal?
There is no criminal, especially after the charge sheet, my lord. And today, because the judgment cited by my friend, my lord, it was talking about High Court should not scuttle the investigation at the initial stage. Now we have passed that initial stage, my lord.
Yes, yes.
We even have the charge sheet.
Yes, yes. We have noticed that, my lord. Thanks for
That's my
reminding.
small submission.
Okay.
And the other submission, my lord, that there may be an angle of corruption or anything, my lord. Only certain charges can.
We are not at all concerned.
My lord, that will be beyond the scope of this FIR. My lord.
This court is also conscious of that.
Obliged.
Yes. Any other? No, there is. Mr. Paske is not supporting your case.
Actually, 482, he cannot be a party to this case also.
It is a strategy by the petitioner. He has intentionally brought him to support his case. Anyway, we'll just see if we can pass order today. Hard land counsel of the parties. We pass order. You said yes. Thank you, Mr. Das. Perhaps you may realize sometimes this court talks more than a lawyer, isn't it? 30 years on the other side, so habit would not go easy. Thank you.